The Honorable, the Supreme Court.
Morning, everybody. Thank you all very much. Please be seated. And the live stream, yeah. So start the live stream and go ahead, call the case when you're ready.
Good morning, Your Honors. The matter before the court this morning is the case entitled The Bank of New York Mellon versus Daniel Quinn, case number 24 AP 359. Representing appellant, the Bank of New York Mellon, is attorney Sheldon Katz. Appellee Daniel Quinn is self-represented. Representing amicus curiae Vermont Legal Aid is Dylan Shapiro. Seated at counsel table with Dylan Shapiro is attorney Grace Haz.
Okay, before we start, have you all decided how you're going to divide up time? Is there an agreement? What is the agreement? If you don't mind.
Taking the first 10 minutes for amici and we'll hand it over to.
Okay, and you alerted our very able bailiff to the lights that you're looking for? Yeah? Okay, all right. So we'll hear from counsel for the appellant. Please come on up. And to get started, if you would, for the record, introduce yourself and identify your client.
Yes, Your Honor. Thank you. My name is Sheldon Katz, and I represent the appellant who was the plaintiff below.
Thank you.
In 2009, appellant commenced foreclosure action against the appellee. From the beginning, it was appellee's position that appellant lacked standing because the appellee, the defendant, he said he did not sign a promissory note payable to the plaintiff. It was a negotiable note, so it had been negotiated. And the mortgage he signed was in favor of Mortgage Electronic Registration Service, otherwise known as MERS, as the nominee for the original payee of the note. Obviously, there's been a long and convoluted history over 16 years. Finally, the case came to trial before Judge Corbett in 2024. After the trial, Judge Corbett issued an opinion finding that plaintiff had proved all of the elements of the foreclosure action at the time of trial. However, Judge Corbett said that under Kimball, the U.S. Bank, which this court decided in 2011, 2 years before this case was commenced, he was compelled to rule that plaintiff had no standing and the court had no subject matter jurisdiction after 16 years because there was no evidence that plaintiff was in possession of the note back in 2009 when the complaint was filed.
Could you have withdrawn your original action after our decision in Kimball and refiled?
Could we have? Of course, we could have, but we were in the process of litigation. I'm not sure. That is a possibility, but there were other things going on at the time that
But that would have
case
allowed you to cure the problem that was identified in Kimball and the requirement that you have the note when you file.
That's a possibility. Yes. I'm not sure that there's any precedent for requiring that in those kinds of, those kinds of
It
circumstances.
certainly wasn't required. It was totally up to
And I'm
you,
not sure
but
that, well, actually, I'm not sure that we
might
could,
have
we would have,
avoided 15 years.
right. We could have waited. Well, I wish if I had known and I wasn't the attorney, if the attorney at that
Would have
time had
refiled.
known, certainly if we had a crystal ball, we would have done that. But there were a lot of other things going on. This case was in mediation for well over 2 years, where the court said finally that the defendant had been delaying the case for 2 years. So there are a lot of other things going on. If I, going back, maybe that would have been the best thing, having determined that we didn't have the documentary evidence on the note. But in any
Would there have
case,
been any other way to address the lack of standing
other
Well-
than withdrawing and refile?
Uh, well, for one thing, I object to the term standing, with all due respect, because I don't think this raises a standing issue, or at least not constitutional standing.
What do you mean by that?
Well, constitutional standing is generally an issue where in claims by private citizens against the government that raise public policy concerns. And out of a separation, and standing actually is
There are
raised
many,
because,
many examples of standing issues raised in private litigation between private parties.
well, this is very important, Your Honor, because there's constitutional standing based in our Constitution, and generally that that doctrine comes out of the concern about separation of powers, where
No,
the
I understand that, but why raise it here? What is the purpose of talking about constitutional standing from your point of view here?
well, I only raise it because Judge Corbett felt compelled to follow Kimball, which itself was based on constitutional standing. If it's not constitutional standing, then it's
Where
not
does it say
subject matter.
constitutional standing in
Yes.
Kimball? It talks about standing.
Well, however,
It's your term, constitutional standing, not the court's term in Kimball, isn't it?
I'm not sure that Kimball used the term constitutional,
I
but
don't
it
think
did
it did.
cite. Sorry, I'm sorry.
Yeah, I don't think it did. Sorry. I have this earpiece that gives me a lot of trouble, and I am begging for some other solution. Is there another solution?
Have another one.
Thank you. We're not going to count this against your time. Oh, it's a headphone. Okay, thanks, Em. Thanks. Anyway, the notion of constitutional standing is your term. It's not the court's term in Kimball.
But if this is not constitutional, for one thing, Kimball was based on cited two constitutional standing cases, Parker v. Town of Milton and Broad v. Agency of Natural Resources. So it was based on two cases that were in turn based on constitutional standing.
Some state actions based on some claim with regard to state action.
Yes,
I
exactly.
understand that, but that still doesn't address the point that the court did not use this term constitutional standing in the Kimball decision.
And again, I'd have to go check, but it did cite these two cases that were constitutional issues. And if it's not constitutional standing, then it's really prudential standing, which does not raise the concern of the
But Mr.
court's
Katz, would
subject
you
matter.
agree that your client had not yet suffered any injury at the time it filed the lawsuit? If it wasn't the holder didn't have the right to enforce the note, then it hadn't suffered any injury at the time it filed the lawsuit, right?
Well, I think, with all due respect, Your Honor, that you're jumping to conclusions that it didn't have the note. There's a
Well, it
difference
didn't prove
between.
that, it didn't prove that below, correct?
It
that was
didn't
the whole
prove
point.
that. It also was not disproved. But
Well, wouldn't you have the burden to prove that?
well, we have the burden to prove it, but the question is when. We proved it in 2011, in 2024 at trial. We also proved it well before. I mean,
That you
even,
had the note before you filed the case?
no, that we
Exactly.
had the note
So
at
then
the
what- if
time.
not, what injury did your client suffer at the time the case was filed?
Well, you're moving the burden of proof back to the time of the complaint. Now,
No, what the
Now-
judge is asking you is, this is a concept that's rooted in case or controversy.
well,
That's what my colleague is getting at, case or controversy. Did you have a case or controversy at the time you filed the case? That's what standing's about here, and that's the way we've interpreted it in Vermont.
well, with all due respect, Your Honor, again, you're getting back to constitutional standing on which Kimball was based. Now, the court promulgated and the legislature enacted in 2010, again, after this case was filed, the court or the legislature enacted 80.1B of the civil rules, which required pleading possession of the endorsed note at the time of the complaint. That was not a requirement at the time this case was filed. So now you're applying this retroactively to a pending
But leaving aside
case.
that rule of civil procedure, if it hasn't this court referenced in other cases, including the Daniel versus Mortgage Network case, the longstanding contract law principle that a plaintiff who's not a party to a contract does not have standing to challenge a breach of contract? Doesn't that date well back prior to Kimball and long back into the court's case law? In
Of
other words,
course, Your
standing
Honor.
exists. Standing is, for example, in contract cases between private parties. A party must be a party to the contract in order to have standing to.
Right. For
bring suit a
example,
breach.
this court's decision in Bischoff was based on a non-contractual, a non-party to a contract trying to enforce a contract. And that was a standing case, but that was prudential standing. It wasn't a matter of subject matter jurisdiction. It was a part of the common law. It was common law standing. And at that
It
point,
stands for the principle that a party has to have the right to enforce a claim in order to have a case in controversy, and in order to have suffered injury, in order to be subject to this court's jurisdiction. I don't understand the constitutional prudential distinction you're making.
constitutional standing invokes that raises subject matter jurisdiction, whereas prudential standing is codified in Civil Rule 17, real party and interest, so that if an opposing party or the court says, well, wait a minute, you're not the real party of interest, but then it allows substitution. It still has subject matter jurisdiction. I mean, subject matter jurisdiction is defined by the statutes of the Vermont statutes,
When
and
did
it
the-
specifies.
When did the bank move to be substituted as the real party in interest?
Well, it started as the plaintiff.
Did it ever file a motion under Rule 17?
No, because it didn't need to be substituted because it was the plaintiff right from the beginning.
Right.
It
So
was the
how does
plaintiff
Rule
right from the
17
beginning. And so there was no need to substitute it. Now, several distinguished Superior Court judges have questioned the application of subject matter jurisdiction and constitutional standing to matters of private law or matters that's between private parties. So Judge Corbett said quote, he believes that the use of the standing doctrine leads to confusion and incorrect conclusions in foreclosure cases, end quote. Judge Crawford, Aurora Loan Services, quote.
Attorney Katz, though,
Yes.
how, if we remove the standing issue, what stops an institution from filing a lawsuit, whether or not it has ownership of the note at the time of filing, to establish that it has the right to do so, given that what would be the suggested cure is that they just do a Rule 17 substitution of counsel. So you might have the wrong party in interest starting out each of these cases and then substituting in.
Well, you've got Rule 80.1B, which now requires that the plaintiff plead possession of the note, and that is actually reinforced by Rule 11. So I don't think this is a problem that usually exists, and it's not, again, it's not a question of whether it did have it, it's a question of evidence. Now, if you put the burden of at least raising the issue on the defendant, then the issue could have been addressed at that time. I think if
But he did raise it, I thought. I thought you.
no,
I don't know if I said
what he did, he said that he didn't sign a promissory note to the plaintiff.
To the plaintiff.
Correct, because it was endorsed. The plaintiff could be, and it's not a contract claim. A note is not really a contract claim. It's a negotiable instrument claim. And under the UCC doesn't require a demonstration of possession of the note at the time of the complaint. So,
But isn't there a further issue factually that the original note that was filed with the complaint is different than the note that was actually presented?
but at that time it was notice pleading. So we gave notice that we had the right to enforce the note. At any time, he could have said, well, wait a minute, this complaint.
Right.
He
but
could have
you
moved
did-
to
But you
dismiss.
didn't, it was a different note. You can't trace back ownership of the note to your client to the time of filing. So we have this gap. Now, I understand you're making the argument that, oh, we always had the note. But at the same time, you can't prove that. You can't prove that initial ownership. So to the extent that, in fact, there's circumstantial evidence that suggests there was at least a different note in circulation that was attached to the complaint. It wasn't that there was no note attached to the complaint, it was a different note.
But that was at the time that there was only notice pleading. There was before
Understood.
80.1B.
But it comes back to the concern that I asked before, which is what stops a plaintiff from bringing a case without necessarily having the ability to do so. Apart from 80.1, this suggestion that the UCC simply allows, or, it doesn't require a presentation of the note, or the idea that you don't have to have, you can go by notice pleadings. What stops someone who doesn't have all their ducks in a row in the most positive way, or in the least positive way, doesn't have the note from filing suit?
And requires a defendant to go through a decade of litigation when that note wasn't in your client's name.
Well, it was at any time. In fact, in 2010, 2 or 3 months after the complaint was filed, the attorney said, it's in my office. He told at the time, Judge Cohen, that the note is in my file, so we can produce it. We could have produced it at any time. We just didn't have the documentary evidence showing the movement of the note, but the attorney had it in his office. Then in 2000, I think it was 12, and there may have been a motion even before then, but in 2012, the plaintiff filed an affidavit saying that, and that was the basis for Judge Garrity's
Okay,
summary judgment ruling.
okay. Time is up.
Thank you, Your Honors.
Thank you very much. We'll hear from counsel for the appellee. Please come on up for the record. Identify yourself and your client before you proceed.
Good morning, Your Honors. Dylan Shapiro on behalf of Amici Vermont Legal Aid and the National Consumer Law Center.
Thank you.
Appellant asks this court to carve out an exception to the requirements that every litigant invoking this court's jurisdiction, whether those claims sound in public or private law, have standing at the time that they filed the note. Kimball didn't break any new ground in applying this holding to foreclosing plaintiffs. It simply applied it as it applies it to all other litigants, regardless of whether the claims sound in public or private law. This court has applied that basic requirement that a plaintiff show injury in fact at the time of filing and at the time of invoking this court or any other court in the state's jurisdiction since at least 1845, when it routinely applied it in ejectment actions. Appellant could have voluntarily dismissed under Rule 41 as early as 2010, when now Justice Cohen indicated that it would need to show standing at the time of moving for judgment or at trial. Certainly after this court in Kimball reaffirmed that that was the requirement, the appellant could have voluntarily dismissed and refiled and cured the issues it's facing today. Instead, it's waited nearly a decade and a half, bringing us here today. This court should not overturn Kimball and upend standing requirements in this state on the basis of these choices made in the litigation of the past 15 years. I want to attempt to clear up some of the confusion around the real party and interest rule that the appellant raises here, and that some of the lower courts have suggested works as effectively a substitute for standing in private litigation. It's not a substitute for standing. Much of this confusion arises from lower courts relying on the leading treatise on federal jurisdiction, Wright and Miller's federal jurisdiction, particularly sections 1545 and 3531, which discuss risks of confusing the real party and interest rule for standing in private litigation. But it doesn't create an absolute rule that real party and interest is the appropriate rule in private litigation, and that standing has no role in that litigation.
But
And
how do you explain Rule 17's provision that a case shall not be dismissed until, if we don't have the real party and interest, until adequate time such that the real party and interest can be substituted?
I think, Your Honor, I think
Does Kimball nullify Rule 17 in these situations?
no, Your Honor, they go to separate questions. Standing asks whether there's an injury in fact, causation, and redressability at the time of filing. The real party and interest asks whether the party that instituted the case had the legal or statutory capacity to do so. And I think referring earlier to the text in Rule 17A helps elucidate that. It refers to the executor, administrator, guardian, bailee, trustee of an express trust, third-party contractual beneficiary, or party authorized by statute may sue in that person's name without substituting the party that would be the ultimate beneficiary. So for instance, in the case of a trust, where it doesn't have the legal capacity to file in its own name, the trustee should be the one to file. And if the action was accidentally filed in the name of the trust, it would be appropriate to substitute the trustee. But the trust, who has the actual legal claim at issue, would always have needed to have standing at the time of filing.
Who bears the burden on proving standing prior to 80.1? So 80.1 clearly puts that into an element of the pleading, but prior to that, if a plaintiff comes forward and says, I have the note, I own the note, and represents it in its pleading, who bears the burden of challenging that standing and proving that standing?
Your Honor, the party invoking the court's jurisdiction has always had the burden of proof on standing, whether in Kimball or prior to that. It's the burden, and as Justice Cohen noted in 2010, the appellant would need to prove standing by the time it got to moving for judgment or a trial.
So all the defendant has to do is simply raise the question of, I don't think they own the note. And that then puts it into plaintiff's corner, notwithstanding plaintiff's representations to the contrary.
Because standing is a matter of subject matter jurisdiction, the burden is on the party invoking the court's jurisdiction, and the court could raise it sua sponte even, and the burden of proof remains on the party invoking the jurisdiction of the court. And I want to point out that that confusion around the real party and interest rule raised in Wright and Miller is the basis for each of the courts cited by the lower court in this case for the proposition that the real party and interest rule is the appropriate rule here. All are overstating that statement in a leading treatise, and this court has an opportunity here to correct that misperception. And with that, I want to turn it over to Mr. Quinn for the remaining 5 minutes.
Okay, thank you very much, Mr. Quinn. Let's check in, see how much time you've got.
I'm sorry, Your Honors. It seems like I have written down what I wanted to do. You have another 5 minutes, Mr. Shapiro. I inverted the time. I apologize.
You don't often come to this court and get a gift like that.
Can I ask, what does Mr. Quinn gain if the court rules in his favor? Would the bank be precluded from bringing suit again?
So it depends on whether the suit is dismissed with or without prejudice. And we would recommend that this be remanded to the Superior Court to determine that in the first instance. As Kimball noted, the default rule in the mortgage foreclosure context would be a dismissal without prejudice. We think there may be reasons for a Superior Court to conclude under the equitable considerations that Kimball indicated that this suit should be dismissed with prejudice, given the litigation choices in this matter and the fact that it's wasted judicial resources and Mr. Quinn's time and stress and mental health over the past decade and a half. However, we'd recommend remanding it to the Superior Court to make that determination in the first instance.
But isn't the case law well settled that dismissal for lack of subject matter jurisdiction is not on the merits and therefore is without prejudice?
That's not what this court held in Kimball. It explicitly held that when a matter is dismissed for lack of standing in the foreclosure context, it should be without prejudice, absent those equitable considerations. And that would not, without prejudice, would not apply Senlar versus Mellon that the lower court insisted would preclude any recovery on the interest. in this case.
But doesn't Judge Corbett's decision in the lower instance really spell out the equities in this case, which is Judge Corbett, I think, went out of his way to make findings that this was really, if anything, unfair to plaintiff. And so on the record that we have before us, we could weigh the equities at this point in time, couldn't we?
Your Honor, I think it would be worth remanding to the Superior Court to consider the equities regarding whether voluntary dismissal was appropriate and wasted judicial resources in this case, as Your Honors have raised. So that's one of the reasons we would recommend remanding in this case. One additional point I want to detail is that appellant insists that prior to Kimball, there was no requirement that a foreclosing plaintiff prove standing at the time of filing. Appellant raises no citations for this proposition. Indeed, the lower court here, now Justice Cohen, indicated in 2010 that the plaintiff would need to prove standing, and Kimball itself was affirming a lower court's order that the plaintiff needed to prove standing. Kimball simply applied the basic principle of standing to foreclosing plaintiffs and said that there's no exemption to it in this context. So the idea that Kimball invented a new requirement simply isn't backed up by case law. And as every other court nearly every other court that has in a jurisdiction that relies on judicial foreclosure proceedings has held, many of them have adopted Kimball, and none of them have explicitly adopted the appellant's argument that the real party and interest rule is the correct one here. I believe 17 or 18 courts in courts that utilize judicial foreclosure proceedings have explicitly adopted this court's holding in Kimball, and the remaining 3 have not explicitly disavowed it or indicated that they would oppose it if the issue was presented to them. Finally, we want to note that appellant's concern that Kimball is punitive and applied retroactively simply doesn't make sense in this context. Appellant's sole citation for the idea that Kimball can't be applied retroactively is Myers versus Baker, which cites the federal ex post facto clause on criminal punishments, which is simply inapplicable here. And more importantly, the appellant has been on notice since at least 2010 in the order denying summary judgment that it would need to prove standing. As Your Honors have pointed out, this should have been voluntarily dismissed to cure the issues we face today. And the fact that it wasn't does not make the application of Kimball punitive in any way. Finally, I want to address the issue of Rule 80.1b. Rule 80.1b actually imposes a higher threshold than Kimball does. It requires attachment of the note and the mortgage deed at the time of filing. Kimball, because it's a matter of standing, requires, like anything else, that the plaintiff plead it has standing at the time of filing and prove it that it had that standing by the time it moves for judgment or at trial. Rule 80.1b isn't a substitute for Kimball. It imposes additional policy judgments that the legislature has made that it's worth requiring foreclosing plaintiffs to attach the note and the mortgage deed at the time of filing, likely to avoid precisely the issues we face here today. But it doesn't obviate Kimball in any way that the legislature has chosen to impose additional requirements on foreclosing plaintiffs. And now I want to turn it over to Mr. Quinn.
Thank you very much. Mr. Quinn. For the record, sir, please introduce yourself before you start.
My name is Daniel T. Quinn. I am the defendant appellee in this case.
Thank you.
Thank you, Your Honors. May it please the court. In my previous oral arguments in this case, I began by saying this case tests whether or not there is a two-tiered system of justice in Vermont, with one set of rules and laws for the wealthy, the powerful, and the privileged, and a completely different set of rules and laws for the common citizen. There's no longer a test, it's an expose. It takes a great deal of courage to admit when one has made a mistake. Judge Garrity showed such courage in 2010, when in vacating summary judgment, he admitted he made a mistake 7 years earlier in failing to uphold conditions and orders of Judge Cohen, orders this court determined were a roadmap in order to foreclose. One sentence, an amicus brief that is perhaps most important, is on page 10. The stark reality that 94.7% of Vermont foreclosure defendants were unrepresented heightens the urgency of such protections for homeowners. 94.7%. According to the Department of Financial Regulations, there have been more than 15,000 foreclosures in Vermont since Judge Cohen issued his orders in 2010. Presuming the 94% statistic holds true, that means approximately 14,000 Vermonters were also pro se and without legal counsel against entities like Bank of New York Mellon, one of the largest and most powerful financial institutions in the world. And Bank of New York Mellon is not even a plaintiff here. There is nothing connecting this defendant with this plaintiff. Instead, an entity known as Shell Point is here. And Shell Point is actually a shell game. Bank of New York Mellon is not a party of interest in this case and has never been.
Didn't the bank prove ownership of the note at the trial?
Absolutely not, Your Honor. The bank was not represented. Shell Point was a trial. There is nothing that indicates any relationship with Bank of New York Mellon. Nothing. Back to day one.
Didn't Judge Corbett find for the bank on the merits?
Yes, he did. Yes, he did. But again, and I take exception with a judge writing a brief for an opposing party. But that's in my brief. Ultimately, this case is not about Bank of New York Mellon versus Daniel T. Quinn. This case is about you, the Vermont Supreme Court, versus thousands of Vermont property owners and their rights against the powerful and privileged. I hope, like Judge Garrity, you have the courage to admit past mistakes here and correct them, especially in the wave of foreclosures that are coming. Having lost in the trial court in 2022, Bank of New York Mellon petitioned this court to change the rules just for them, and this court did. Having lost in 2024, despite the rule changes, Bank of New York Mellon now asks this court to change the laws just for them. I hope and I trust the court has the wisdom and the courage not to do so. Thank you.
Okay, thank you. Does the appellant have any time?
Appellant has no time remaining.
Then let's call a conclusion of the hearing.
The next hearing for the court is scheduled for 10:45 this morning.
Thank you.